Swayam Prabha. Digital India. Educated India.
I am Dr. Surendra Mehra, Assistant Professor, Law Department, Banaras Hindu University, Varanasi. So, this is my 6th lecture on temporary injunctions and interlocutory orders under Order 39 CPC. So, this order temporary injunction or this relief in under CPC is very important relief, because this order 39, if you get relief or if your application under Order 39 is accepted by the court, then you can save your property from wastage, from alienation, from damaging, all those reliefs what has been mentioned in Rule 1 itself. So, although apart from this Order 39 CPC, we have permanent injunction also, that is in Specific Relief Act 1963. In CPC, we have only Order 39, which talks about temporary injunction. This is not permanent injunction, this is temporary injunction in CPC, what we are going to discuss now. In Specific Relief Act, we have from section 38 to 42 in Specific Relief Act 1963. These section 38 to 42 deals with permanent injunction. So, some students ask number of times this question also, okay, sir, is it permanent one, or although the name is there a temporary injunction, but still they are confused what is the difference even between temporary injunction and permanent injunction, or where we will get the provision of permanent injunction. So, I will discuss all those things, temporary injunction as well as permanent injunction, little bit about permanent injunction. I will tell you in this PPT itself or in this lecture itself. So, this is temporary injunction, again mind it, in CPC we deal only temporary injunction and interlocutory orders. Apart from this, what I have seen, students are also confused with interlocutory orders, interim orders or orders, as well as interlocutory applications. So, here I will tell you about this one also, ki what is interlocutory order, what is interlocutory application, and what is interim orders. So, these things are very important one. So, under Order 39 CPC, first of all we will try to get the meaning of temporary injunction. Temporary injunction, an injunction is a judicial process whereby a party in an order to refrain from doing or to do a particular act or thing. Temporary injunction is a injunction, or temporary injunction is a judicial process by which parties are ordered either to do some particular act or to refrain from doing some particular act. Particular act, when you feel ki you are aggrieved one, being a plaintiff, and defendant is going to do some kind of mischief on your property, either he can alienate your property, he can damage your property, or he can do other kind of mischief on your property. When you have or when you get this kind of fear, being a plaintiff, then you can file this application under Order 39 CPC along with your suit, So, in earlier lecture also, when I was discussing Order 33 of CPC as well as when I was discussing Order 32 of CPC, that time also I was telling you ki these applications are filed along with the original or real suit what you file if you need this kind of relief. So, temporary injunction basically compels the opposite party, I will say, because this relief can be attained or can be got by both the parties, plaintiff and defendant. So, basically this compels the parties either to do a particular thing, ki okay, you have to do this thing, you cannot do this thing, This is the this can be the order of the court. In the order itself, court mentioned this word, or court directs this way ki okay, being a plaintiff or being a defendant especially, you can do this thing, because this there is a encroachment, or there can be a suit for recovery of possession, suit for or there can be an encroachment on your property, or any kind of fear when you get this being a plaintiff, ki yes, the defendant or the opposite party against whom you are filing your matter, ki yes, this party can do this kind of mischief, or this kind of wrong with your property, this kind of, and this will cause irreparable loss to you being a plaintiff. So, this kind, for in order to, or from protecting your rights, or for protecting your legal rights, you can file application under order this 39 of CPC, that is for temporary injunction. So, temporary injunction, I told you ki this is a judicial process by which court compels the opposite party. So, these are only meanings, I mean what I have write, because here in third part of this one also I have written ki where there is a UB just IB remedial, ki where there is a right there is a remedy. So, this is just a sporting principle, like ki where there is a right there is a remedy also, ki if you feel ki you are aggrieved one or opposite party doing some kind of wrong with you, then you can get remedy also for this, and this is a kind of remedy, order 39 of CPC, temporary injunction, and this is equitable one also. This is a diagram, and with this, with the help of this diagram also you can understand. I have divided this one division according to time period. This is permanent injunction, this is temporary injunction. Permanent injunction I told you, and sometimes we call it even perpetual injunction also to this permanent injunction. So, do not get confused with this word ki is there any difference between permanent injunction and perpetual injunction. Permanent injunction and perpetual injunction basically means when you get or decided your case on the basis of merit, when you get decree finally, that is permanent injunction. When you get relief in the form of decree, or when the court decides your case finally on the basis of merit, that can be a permanent injunction, that can be a perpetual injunction, and this is there in specific relief act, section 38 to 42 of CPC. So, for this you can read specific relief act. Temporary injunction we have from rule 1 to 5 of CPC under order 39 of CPC. From 6 to 10 we have interlocutory orders. Interlocutory orders are also nothing else, these are the examples basically, interlocutory orders. These are also temporary in nature. Otherwise, if I just tell you ki okay, this is temporary injunction, if I tell you ki okay, ki this is judicial process by which the court compels the opposite party or the party ki okay, either to do this thing or to refrain from doing this thing. So, you student cannot understand only this, the meaning is not enough, meaning is, I mean this will not give you a kind of satisfaction, but if you read rule 6 to 10, those I mean interlocutory orders, so you will get temporary injunction or temporary injunctions basically we get in the form of interlocutory orders, which are, although which are not deciding your case finally, but you will understand ki okay, in case of sale, in case of breach of contract, in case of damage or preservation of your property, in case of money matters, in case of land acquisition, okay, these kind of the things, these are the examples with which I mean we can get these kind of orders, and with the help of those orders from 6 to 10 you can get ki okay, this is temporary injunction. Sometimes we discuss in our class only okay, this is the meaning, but this is not enough. I think the examples what we give in our classes, that is more fruitful. With those examples student can understand more about the basic provisions, like what I am telling you ki we have, I will discuss all those things in detail ki okay, what is rule 6 to 10. What is, I mean what are the examples of interlocutory orders. Just by saying interlocutory orders again student get confused, but if you read the language of section 6 to 10, if you read those examples properly, then you will understand ki okay, these are orders, and these orders we can get in the form of temporary injunctions, and we call it even by other name also, that is interlocutory orders. So, according to nature again we have mandatory injunction, we have preventive injunction, all those things are in specific relief act itself. What is mandatory injunction and what is preventive injunction, these are the meanings. with this also you can understand. Perpetual injunction, this section of specific relief act, the decree made at the hearing and upon the merit of the suit. The decree made at the hearing and upon the merit of the suit, the defendant is thereby perpetually enjoined from the assertion of a right or from the commission of an act which would be contrary to the right of the plaintiff. Like if you file any case and finally after doing or after trying the case completely, after leading the evidence, after hearing all the parties and accepting all the evidences, whatever the relief is given by the court, whosoever is the decree holder or judgment debtor basically. So, we get basically the whatever the outcome of the result, that can be perpetual injunction, that can be permanent injunction. So, basically permanent injunction we get at the hearing in the last, because this is after deciding or on merit your case, only then you get perpetual injunction or permanent injunction. Before that, during the trial, whatever small order you get, that could be or that can be a temporary relief only. So, temporary injunction, now see this one, this is perpetual injunction is there in the specific relief act. Temporary injunction is an interim remedy. Again this word interim remedy, it means interim relief in between whatever the relief you get as per the need of your case, as per the subject matter of the suit, whatever relief you need. Like order 33 is also a kind of relief, if you get permission of indigency. Under order 32 is also a kind of interim relief, interim remedy, if you get appointed any guardian or next friend. Under order 32 of CPC I am talking. 33 also a kind of interim remedy, 39 is also a kind of interim remedy. Interim remedy means in between, during the trial, if you feel no, this can be, this loss can be caused to me, or the opposite party can do this kind of mischief with me, or mischief with the property, wrong with the property, whatever the subject matter, you have to see as per your matter, okay, this is the matter, I mean this is the case of this is the subject matter of your case and you need this relief, then for that you can get temporary injunction, you can file application along with your original suit application under order 39 of CPC. So, this is interim remedy to maintain the status quo, basically this is for the preservation of the subject matter. This will provide you status quo, or this will keep the property intact as it is in the same form, whatever the position or whatever the situation of your property, if there is a immovable property or movable property, whatever the form is there, then if you feel this party or opposite party can cause mischief or can damage your property or alienate property, if you get this relief under order 39 of CPC or court accept your application, then the party is bound to keep the property as it is, the opposite party I mean to say. They cannot do anything, any wrong with the property, they cannot touch the property, otherwise the contempt proceeding will be there. Although this relief is there, if there is a disobedience, then you can get 3-month imprisonment also, or your property can also be attached. Apart from this contempt proceeding, proceeding is a general I mean proceeding, because we have already special provision we have under order 39 of CPC. In case of controversy, when you have a special provision as well as general provision, then special law will prevail, special provision will prevail, and order 39 is one of them. This is a special provision. So, we talk sometime about contempt proceeding also, but that is a different thing. But if you do something or if you do not obey the order of the court against whom the court has passed order, then there can be imprisonment or attachment of property, 3-month imprisonment, attachment of property. So, this is interim remedy to maintain the status quo. This order, this relief under order 39 of CPC will give you a temporary relief. This will keep your property intact, whatever the status of your property. Nobody, neither plaintiff nor defendant, they cannot touch then property if this relief is granted by the court. They cannot do any kind of alienation, they cannot I mean waste the property or damage the property. The property will remain until and unless the court decides the case finally. Whatever the shape of the property, that would be there throughout the proceeding. Only after hearing the case finally, whatever would be the decision of the court, then you can do anything with the property. or decree holder can do anything with the property. But before that property, if status quo is granted by the court, then there can be no interference, there can be no change in the shape, in the form of the property, whether movable or immovable property. This is the purpose and this is the object of temporary injunction. This preserves the subject matter of the suit, preserves the subject matter of the suit, order 39 relief CPC. Temporary injunction apart from this one also ki continue until a specific time, and this relief can be event wise, date wise, result wise. Date wise, okay, from this to this date you cannot touch this property. If temporary injunction, as per the need of the case, court will grant this relief. Okay, from this date to this date, for 2 months, for 3 months you cannot touch this property. Result wise also you cannot touch this property, or you cannot do any kind of alienation or wastage. Date wise, event wise, result wise, this relief can be there. Specifically in the order sheet itself, court mentioned this one, and this is the same order what you get, what you have read under order under section 2 rule 14, section 2 rule 14, the same thing I have discussed in decree and order session. In my lecture, when I discussed this decree and order, I told you this one also, ki what is decree and what is order. This interim order is the same order, because these are small orders. What you get, or what you get basically on the basis of your need during the pendency of the suit, during the trial, what you feel ki you need this relief, immediately you need this relief, otherwise this loss can be there, irreparable loss can be there. So then court can grant this one. So this will continue until a specific time or until the further order of the court. Court mentioned in the order sheet itself ki okay, this will be for this much time, or until the court orders further pass the order. May be granted at any stage of the suit. See this one, this is again I am repeating it, during the pendency, during the trial of the suit, at any stage you can get. It does not mean that on the first date of hearing itself, when you are filing your original suit, you feel no, you should get this relief immediately, you should file application under order 39 immediately. No, even if you after 6 months or after 1 year during the trial, if you feel you aggrieved party, this opposite party can do this kind of thing, if you get this kind of apprehension being a plaintiff, then also you can file this application under order 39 of CPC. This is a judicial process, and court is bound also. If you prove prima facie case, if you prove irreparable loss, if you prove balance of convenience, if you prove if your conduct is honest and fair one, these 4 guiding principles are there for this one, for in order to get this relief under order 39 of CPC. So all those things are, so that's the reason I am telling you that this is a very good relief. In criminal matter you hear about bail, okay, if your party court books the or police books the party, then you get bail, file in bailable matters you get bail, in non bailable matters also get bail. So in CPC I think this is also equivalent to that relief in civil matters. Criminal matter bailable, and I am just giving example just for your understanding, because you people take much interest in criminal matters. So normally in my classes also I give the examples of criminal cases, because you people will understand, you can relate it ki okay, this is the difference between civil and criminal matter, and this kind of relief is also equivalent to those reliefs. If you get status quo, if you get this temporary injunction, that is equivalent to, this will enhance your confidence, this will enhance the confidence your party, or to say your client. So this can be for a specific time or further until the further order of the court, and that may be granted at any stage of the suit, at any stage of the suit. I told you even after 6 months, 1 year, or whatever the time you feel now there is an apprehension, opposite party is going to do this thing. And I will always say to students also this is the quality of a good advocate. If he is understanding or if he is apprehending something, if he is coming to know no, this is going to happen with his case, he must be aware even about the coming situations. He must know the steps what is being taken by the opposite party. Only then he can become a good advocate. Otherwise, really, because this you will get. This will be useful during your practice also. Otherwise, apart from your examination. So these are further types of temporary injunction: prohibitory injunction, mandatory injunction. Prohibitory injunction only prohibit or restrain someone. But this mandatory injunction compels, this is the difference, prevent and compels. command or some other order some person to do something. This is the difference. Precedent, we have number of judgment also. I have written here few judgments, like in Bharat Petroleum Corporation Limited versus Harichand Sachdeva. In this case, the court observed that temporary mandatory injunction have to be granted only in exceptional cases, mandatory injunction, exceptional cases, because every case is not of, because basically this temporary mandatory injunction compels the opposite party. If you have to see, I mean, the court has to observe the entire or the complete situation or the complete case in entirety. Court cannot decide anything specifically in isolation, like if you are saying ki, okay, this relief sir I need, if you file an application under 39 or in any other order, if you say or just convince the court, so and expect the thing from the court, expect the order from the court ki, okay, I mean, this is my this is my violation of right and I need immediate relief. No, court will not, court has to see, because this is the duty, court is the guardian of the case. Court cannot grant you relief in isolation, only just keeping in mind one fact or keeping in mind one need. So that is the reason we are calling it exceptional situation, because this is basically compelling the opposite party. Compelling means you will be bound by that, and as per the situation, if the thing is not permitting you, because court has to observe or court has to monitor even the limitations of concerned parties also, limitation of courts also. Exceptional situation must be there for mandatory injunction, where there are compelling circumstances, where the injury complained is of immediate, crucial and is likely to cause hardship. If mandatory injunction has to be granted at all on interlocutory application, it is granted only to restore status quo and not to establish a new state of thing. These are the points, bold points, in bold words you will find these are the points which are important for getting temporary mandatory injunction. But one thing is exceptional one thing, another thing is compelling circumstances, another thing is, I mean, this one, this will not establish a, already told you this is only preserving the status, preserving the subject matter of the property. In another case, Gujarat Bottling Company versus Coca-Cola Company, the court observed that temporary injunction in the Indian law is to protect a party to the suit against injury by violation of his right, for which he could not be adequately compensated in damages recoverable in the action. I will discuss it further. What is prima facie case, what is irreparable loss? This is the same thing. Irreparable loss means which cannot be compensated in terms of money, then court will, or court can grant, because all four conditions court has to keep it in mind: prima facie case, irreparable loss or injury, or balance of convenience, as well as the party must be honest and fair one. So compensated, this can be a ground ki, okay, the other, if this relief is not granted, then the party cannot be compensated in terms of money. This is also one can be the criteria. In this another case, court defined injunction, and injunction is judicial process, the same thing. The main purpose is to preserve the subject matter of the suit in status quo for the time being. This is the, I mean, this is not bringing, this relief is not bringing new state of thing. This is only if court grants you this relief under order 39 of CPC, that is temporary injunction, this is only for the preservation of the subject matter of the suit, subject matter, whatever the subject matter, it varies case to case in civil cases basically. Already told you, civil cases means private rights and remedies, whatever property, whatever kind of violation of our civil right, our private right, that is a subject matter of suit as per the case. These are the requirements. These four ingredients for getting temporary injunction: prima facie case, irreparable loss, balance of convenience, and conduct of plaintiff. These are very important one. If you understand this one, then you can easily argue before the court of law also, okay, whether you are entitled to get, you can understand in advance whether you will be get. Although this power is discretionary one, but that must be, discretion does not mean arbitrary exercise of power. Discretionary power of the court does not mean arbitrary exercise. That must be reasonable, must be based on sound judicial legal principles. Court cannot reject this application straightforward, this relief or this prima facie case is not made out, or this relief is not granted because this is my discretion. Court cannot say this thing. If you convince the court with these 4 points, then you will be entitled and you can get this relief in your case. Although this is discretionary one, some students get confused ki, okay, no sir, this is discretion one, court can or cannot grant. No, court cannot go beyond the law. Court has to remain within the purview of law, domain of law, and these are the points as per the case, as per the subject matter of the suit. The first one is prima facie case. Prima facie case does not require the plaintiff to establish a full proof case. What is prima facie case? You people file case, real suit, original suit, you people file, along with if you file this application, or after some time if you file, during the proceeding if you file your aggrieved one. But on the first date of hearing, when you file original suit, on the first date of hearing you establish your case, because the burden of proof from section 101 to 106 of your Evidence Act, 101 to 106 Evidence Act, burden of proof, upon whom the burden of proof lie? Evidence Act 1972, 1872, this one, 101 to 106 Evidence Act. So, prima facie case, the burden of proof is on, in civil matter, on the party who is asserting something before the court of law. Otherwise, court can ask any question, because court has to find out whether there is a cause of action, whether the court has jurisdiction, or on the basis of the cause of action court decide even the jurisdiction matter also, whether subject matter jurisdiction court has or not, whether pecuniary jurisdiction court has or not, whether different original or appellate jurisdiction court has or not, territorial jurisdiction court has or not, on the basis of cause of action. So, on first date of hearing, basically, because you have to understand the entire structure of your trial, structure of civil case trial, then you can easily come to know what is prima facie case, what is irreparable loss, what is balance of convenience, what is conduct. On the first, after filing your plaint under order 7 of CPC, on the first date, the matter, when matter comes before the court, on the first date of hearing, you have to prove your case prima facie, although you submit your original document also along with your plaint. But sometime you may or you may not, suppose there are 10 documents, but right now at the time of filing you have only 5 documents in your possession. So, that is the reason this kind of problems comes. Apart from it also, otherwise, because if you people file, suppose original document along with your plaint, then also on the first date of hearing court can ask any question relating to what is your claim, what is your matter, regarding the cause of action, court can judge this kind of things, court can examine. Prima facie court has to just satisfy whether this is a really genuine case or fake case. There are number of civil matters, number of people who are just trying for the harassment of the opposite party, they are filing matters, because civil matters you have to pay just court fees. This is paid service, again I am telling you. There is no check on this. Check is only in the form of whatever is taking place on the first date of hearing. When judge is asking, court is asking questions, court is examining the plaintiff or the party who is standing before the court. Okay, what is your claim, what is your matter, why you have approached the court, can't you settle it down outside the court, these kind of things. Sometimes there is a communication gap also between the client and the advocate also. Advocates write something in the plaint and client does not know what his advocate is writing in the plaint. This is also one of the problem. So, just to ensure this thing, just to ascertain this thing, whether this plaintiff or the party who is asking for relief or who is filing this matter, whether the party is aware about this suit or not, about this relief, what the advocate is writing, because the drafting, this is done by the advocate. So, if there is a communication gap, the advocate will not tell you the opposite party, tell you the concerned party. So, on the first date of hearing, court can ask this kind of question. But here I am talking about prima facie case along with this original suit. If you are asking for this relief also, suppose you file application on the first date of hearing, along with your plaint you are filing application under order 39 of CPC. Yes, your lordship, I need temporary injunction also, because there are chances opposite party can waste my property, damage my property, alienate my property, sell out my property, or there can be breach of contract. This kind of fear if you have, this kind of apprehension if you have, then even then also you have to establish prima facie case the prima facie thing in your favor. That is the reason ki no need to establish a foolproof case, but he has a fair question to agitate with regard to the existence of his right. Burden is on the plaintiff to satisfy the court by leading evidence for the prima facie case. The burden is already told you on the party who is saying this one ki yes, I need this relief. On what basis you are saying yes, you have a prima facie case? Just by saying this one ki I need, there are chances he can damage my property or waste my property is not enough. First date, just for getting this relief, and I will say even on the first date of hearing, otherwise if you suppose you do not file this application under order 39 of CPC just for the in your original matter, when you are just filing your suit, even on that date also, first date of hearing, court can ask this question, and some court asks this question. Although this is number of I have seen number of people, they are taking it lightly ki okay, whether they are asking or not, let the opportunity, otherwise you people will call ki no opportunity of loss, lack of opportunity of hearing or loss of opportunity of hearing, odi ultum partem. So that is the reason court give opportunity to both the party, just without asking any question, court want to proceed with the case, because the moment court grants this relief, then opposite party will say opportunity of hearing, I mean raise allegation opportunity of hearing, or does not grant, then also there can be, then plaintiff can say or defendant can raise this kind of allegation ki why the relief has been granted or why the relief has, when relief is granted then plaintiff will say ki okay, defendant will say ki no, this is not okay. If not granted, then defendant will say ki this is okay, plaintiff will say this is not okay. So that is the reason court want to say ki let the case decide on merit, opportunity of hearing should be given to both the party, and let this case should be decided on merit. So prima facie case means not to establish a case foolproof, but just you have to show ki yes, by leading evidence, short of evidence, you have to say ki no, such the base of my apprehension is this one, this opposite party can really do this thing, and he has started, or the party has already started or already has done this one. Evidence or witnesses, even you can give produce even witnesses also, you can give some sort of documentary evidence also in the form of photographs or in the form of some other documentary evidence. This can be base of your claim ki okay, yes, there is a prima facie case in my favor, your lordship. So prima facie case is very serious one. Second one is irreparable injury. It does not mean that there should be, and there should be no possibility of repairing the injury, irreparable injury. You can relate this one, like let me tell you this one, rule 1, then you will more come to know. Rule 1 is talking about, I'll take you back again, but see this rule 1 first. When there are chances of damage, alienation by any party to the suit or wrongfully sold in execution of a decree. See this one, that any property in dispute in a suit is in danger of being wasted, removal or disposal of his property. These are the apprehensions. When you get this kind of apprehension, then you can say, your lordship, ki there is a, I mean you should prove prima facie case and irreparable loss, irreparable injury, ki when opposite party or defendant damage your property, alienate your property or sold out in execution, then also there can be irreparable loss or irreparable loss. Now the question arises, what is irreparable loss? We are saying only ki when it cannot be compensated in terms of money, but not only in terms of money. Suppose your opposite party, this relief is not granted under order 39 of CPC, very easy, in I mean easy language I am trying to tell you, convey you this one. Suppose court does not grant you this relief, temporary injunction under order 39 of CPC, and court is considering your application under order 39 of CPC. Then, and the opposite party damage your property, start damaging your property or alienating, start the proceeding of alienation also, or trying to waste the property. If it is a movable property or immovable property, they can cause any kind of damage to the movable and immovable property, any kind of alienation of movable property. Who will take into account all these things? Court is not sitting there, judicial officer are not sitting there ki okay, whether the opposite party is really damaging or alienating or wasting your property. You people know, being a plaintiff, you people know ki yes, in this form or in this way the party is really alienating my property, alienating, damaging my property, wasting my property, or trying to commit a breach of contract, trying to sell it out in execution. You people know. And if this happens really, if this happen really, because see the meaning of this one, it does not mean that there should be no possibility of repairing the injury. There can be repairment of your injury, but who will bear all those, because this would be equivalent to wastage of time, this would be equivalent to wastage of your money. Suppose after 6 months the relief, whatever, what if you get this relief, so you can get immediately on the spot itself, immediately this relief. Yes, now the property will remain intact because temporary injunction is there. But if temporary injunction is not there, then and property, opposite party damage your property, then if you get repair, or after 6 months if you get restitution of that property even after 6 months or 1 year, then why to wait for 6 months or 1 month? Because you are the ultimate sufferer, being a plaintiff, if this relief is not granted. After 6 months if you get something, after 1 year if you get something, or in the form of perpetual or permanent injunction if you get something in your favor, that will not compensate you. It is not a question of money, it is a question of time, it is a question of your all resources, it is a question of your money, your efforts, your peace of mind. It's all these things are related with this irreparable loss and irreparable injury. Although we are saying no, this can be compensated when this cannot be compensated in terms of money. You can get, suppose if you get temporary injunction, property will remain intact, then there is no problem. But suppose opposite party damage your property, and after 6 months if you get 10,000 to 20,000 as per the value of the property, then would it be for 6 months or 1 year or 2 year, whatever the time period is being taken by the court, then who will suffer this one? Who will be more inconvenient? Who will be more hardship, at more hardship? These all things must be understood. This one, first one is prima facie case, you have to prove. Second, irreparable loss or irreparable injury, and third one is balance of convenience. This balance of convenience is also equivalent if it is granted or if it is not granted. Court has to see the interest of both parties. Court cannot be biased one. Court can neither speak in favor of plaintiff nor in favor of defendant. Court has to maintain the balance actually. Who will be more inconvenient if it is not granted? Who will be more inconvenient? Who will be more at hardship? Who will be more in trouble if this is granted and if this is not granted? Whether plaintiff will be more inconvenient or defendant will be, because this is temporary one, the case has not decided so far on merit. This will be decided subsequently on merit. Only then you can say, but suppose today you are asking some relief from the court, being a plaintiff and saying, your lordship, this is my prima facie case and irreparable loss will cause to me if this relief is not granted. Can court say with full proof, with straight jacket formula, or with sort of concrete evidence, really you are the entitled or you will be the decree holder subsequently? No, court cannot say this thing, you will be decree holder tomorrow, unless and until the matter is decided finally. That is the reason court has to maintain a balance right now at this particular stage. When you are asking relief under order 39 of CPC during the trial of the case, then court cannot say this thing, yes, you are right one and you are wrong one. Court cannot say this thing. Court will say this thing with full confidence when the case is decided on merit. This is what I am saying, who will be more inconvenient, who will be more at hardship. Court has to take these points into account while deciding the question of order 39 of CPC. What is prima facie case? What is irreparable loss? What is balance of convenience? And apart from it, conduct of the plaintiff should be fair and honest. This is also the court will take into account, or court has to take into account whether you are really honest if you are coming, whether your hand is clean hand or not. Suppose you have committed, being a plaintiff, you have committed something wrong and now you are blaming defendant. Then with the observation, with the case, with the submissions, with your body language, court are very smart one, with the evidence, because these are courts, lower courts are court of fact, with the fact itself on record, with the evidence, with the statement, court can easily come to know whether really you are honest one or trying to become over smart. trying to become smart, then court will not grant you. These 4 points, prima facie case, irreparable loss or injury, balance of convenience, conduct of the party, 4 points must be taken. This what we has, I mean, the Kumar versus Prahlad Singh case, 1993 judgment. Apart from it also we have Manohar Lal versus Hira Lal judgment, 1962 judgment, and for ex parte injunctions we have Murugan Stanley versus Karthik Das judgment. You should go through all these judgment and we will come to know more about it. So, these 4 points in this particular case, Dalpat Kumar versus Prahlad Singh case, this has been decided whether there is a prima facie case or not, whether there is a irreparable loss or injury or not, balance of convenience, conduct of the plaintiff should be fair and honest one. And this is rule 1, already told you these points, damaged, alienation, sold in execution, if this kind of fear you have in your mind, then you can file this application under 39. Cases in which temporary injunctions may be granted. It means these cases are related with the movable and immovable property especially, because we are talking about damaging, we are talking about alienation, we are talking about wrongfully sold in execution, breach of contract. Otherwise also I am just giving examples, mainly this is related with this one, otherwise there will be loss to you. Injunction to restrain repetition or continuance of breach, injunction. See this one, in any suit for restraining the defendant, because language you have to, language of this Bail Act rules you have to take seriously, you have to read carefully, because with the language you will come to know, and along with these few judgments you will come to know more about it what is, because what would be the if there is a repetition, if there is a continuance. In any suit for restraining the defendant from committing a breach of contract or other injury, whether compensation is claimed in the suit or not, the plaintiff may at any time after the commencement and either before or after injunction apply to the court for a temporary injunction to restrain or the defendant from committing the breach of contract or injury complained of. Term, duration of the keeping in account, giving security or otherwise. This is just keyword, I mean, if you feel this one is there, so then you can file application. This rule 2a, disobedience. In case of disobedience, what would be the order of the court? In case of DB, if you do not obey the order under 39 of CPC, then what would be the situation? Then see this one, granting the injunction or making the order, or any court to which the suit or proceeding is transferred may order the property of the person guilty of such disobedience or breach to be attached. This one from here to here in this rule 2a, attachment of property and civil imprisonment for a term not exceeding 3 months, unless in the meantime the court directs the release. This can be the punishment. That is the reason I was telling you this is special provision. General provision is there, sometimes people feel contempt proceeding would be there, but this special provision is there and this will prevail. So, if you do not obey the order of the court, then this can be the punishment, your property can be attached, or you can be civil imprisoned for 3 months also. This one, non compliance, this one is also there, non compliance, the same thing. Nature of order, rule 2a, the same thing what I was telling you, just 3 months civil imprisonment or this one. In this particular case, New Okhla Industry Development Authority versus Atar Singh, this is quasi criminal in nature, rule 2a is quasi criminal in nature, and meant to maintain the dignity of the court in the eyes. Food Corporation of India case, this is punitive. This Amazon versus Future Retail 2021 judgment, again mere disobedience will suffice, or it has to be willful disobedience, this word must be there, willful disobedience. Sometimes disobedience can be there, you have no malified intention, but if your intention is really malified, willful disobedience is there, then this court can avail the benefit, or court can pass order under order 39 rule 2a of CPC. Willful disobedience, this is very important, willful disobedience, malified, willful, intentionally if you are doing something wrong, really you want to harass the opposite party, really you want to damage the property, really you want to alienate the property, then in that situation. Order 39 rule 3, ex parte injunction. Ex parte injunction, the court can grant ex parte injunction. First of all, you should know what is ex parte. Ex parte injunction, one sided decision. Order 9 rule 6 talks about ex parte order, ex parte. ex parte decree, one sided decision, one party, when suppose defendant does not appear, then in that case court can, after serving summons, court can grant. And there is a relief also in rule 13 itself, order 9 rule 13 itself, there is a relief also for ex parte decree or ex parte order. There can be relief also for this one. So, ex parte injunction, the court can grant ex parte injunction when it is under the belief that the object of the injunction would be defeated because of delay. Because of delay, if the court does not grant this ex parte, otherwise this should be on merit, both the opportunity of hearing must be given to both the parties. But if suppose opposite party is not coming even after serving summons, then the purpose of this order would be defeated, because we are trying to protect the subject matter of the suit, we are trying to protect the, trying to preserve the property, we are trying to save the property from wastage, from alienation, from any kind of other disposition. Court is trying to do this thing, but if ex parte after serving summons the opposite party is not coming, then this is the ultimate relief. It means an ex parte injunction can also be there when opposed defendant is not coming. For that, appearance and non appearance, order 9 you should read it completely, order 9 is very important. Ex parte appearance and non appearance of party, what would be the consequence if plaintiff is not coming or if defendant is not coming, what would be the consequences of all these one. So, that is the reason I am telling you ex parte injunctions can also be granted. Certain guiding principles in this particular case, Union of India versus IRA Education, whether the plaintiff will be a victim in irreparable mischief, ex parte injunction, there are, apart from this judgment also there is a Morgan Stanley versus Karthik Das judgment, 1994 judgment, and this judgment is also, there are 7 line principles, 7 guiding principles are there apart from this, because these 3 or 4 principles like prima facie case, irreparable loss or balance of convenience, this is old one now, but so far as ex parte injunction is concerned, there are 7 guiding principles, and in this particular case Morgan Stanley versus Karthik Das, Morgan Stanley, I am writing it so that you can come, although I have not mentioned it, Morgan Stanley versus Karthik Das, in this judgment and apart from this judgment, कि whether the plaintiff will be a victim to irreparable mischief by the defendant, whether the weight of injustice will be heavier if an ex parte injunction is not guaranteed, whether the time of applying for an ex parte injunction was maliciously motivated. These I have mentioned only 3 principles, but there are 7 guiding principles. You should read all those principles, what would be the consequences if ex parte injunction is not guaranteed. So, ex parte injunction can also be there. This is also part of temporary injunction. See this one, rule 3, before guaranteeing injunction, court to direct notice to opposite party. The court shall in all cases except where it appears the object of guaranteeing injunction would be defeated by the delay, before guaranteeing an injunction direct notice of the application for the same to be given to the opposite party. Normally this happens, court serves notice to the opposite party ki okay, let the opposite party come and the opposite party raise any objection if they have any kind of why this relief under order 39 of CPC should not be guaranteed. Serve notice, but when you feel no, this is urgent one, when the court feels you this is urgent one, for this we have this provision ki where it is proposed to grant an injunction without giving notice of the application to the opposite party, the court shall record its reason for its opinion the object of guaranteeing the injunction would be defeated by delay, because at least 7 days notice, at least 10 days notice to opposite party, and if the court waits for this much time, this would defeat the purpose of justice. So, in those cases, in those emergency or urgent situations I will say, court can directly, by recording the reasons ki why the court is guaranteeing relief of this temporary injunction, court can record its reason and grant this one without serving notice to the opposite party. But this is a specific for the time being, to deliver the opposite party to send him by registered post immediate after order payment, or along with the application a copy of the avid plaint and copies. This can also be there, let me tell you this one also ki why this is where it is proposed to grant, let me complete again this one, where it is proposed to grant an injunction without giving notice of the application to the opposite party, the court shall record the reason for its opinion that the object of granting the injunction would be defeated by delay, and require the applicant to deliver to the opposite party or to send to him by registered post immediately after the order granting the injunction has been made a copy of the application for injunction together with. If court grants relief without serving notice to the opposite party, then this can be mandatory, court can make it mandatory for the party in whose favor this relief has been guaranteed, ki okay, now we have guaranteed this order to you, this relief injunction to you, now you should send this order along affidavit, copy of plaint and the copy of document on which the plaintiff applicant relies to the opposite party against whom the relief has been guaranteed. So, that because this is a time barred relief, okay, this is only for this much time, this is for this 1 month or 2 months, whatever the period is there. This cannot be till the decision of the case, this relief, if the court is guaranteeing relief without serving notice to the opposite party in case of urgent situation. Basically, this provision is covering the urgent situation. So, this is how order rule 4, injunction may be discharged, varied or set aside if any dissatisfied party makes an appeal against it, appeal, then this can be discharged or varied. In case of injunction against a corporate entity, its effect applies not only to that entity, but to its personnel as well. This is also very important. If this relief is guaranteed against the corporate entity, then corporate entity personals, its officers will also be responsible for this one. This is also you have to take into account. Now, this is interlocutory order. I already told you interlocutory order, what is interlocutory order, but now with the this one, these rules you can understand how court grant injunction and courts in the form of interlocutory orders. When you file interlocutory applications means same, the same thing, temporary application order 39 of CPC talks about interim sale. Under this, court may order sale of any movable property which are subject to natural decay and will be rendered futile if not sold swiftly. Example, fruits and vegetable, when the property is of perishing nature, then court immediately will grant interlocutory order in the form of temporary injunction. You can synonymously change it, temporary injunction and interlocutory orders. Interlocutory orders are basically temporary injunctions. Like for example, in case of fruit and vegetable, court cannot wait for 6 months or 1 year, because this is of perishable nature, perishable item. Court will immediately, by guaranteeing this relief, court will say okay, now the sale should take place of this fruits and vegetable, otherwise there will be no use of this fruits and vegetable. Second, rule 7, it empowers the court to issue search and inspection, order any property connected to dispute to acquire comprehensive information. This kind of order can also be, interlocutory order can also be passed, to search and inspection order for any property, search and seizure relating to any movable and immovable property. This is also interlocutory order. Rule 8, condition which need to be satisfied to pass order under rule 6 and 7. This is not of that much importance, but rule 9, address situation in which land that pays revenue is the subject of dispute. Okay, this land is in of dispute, now you should give immediate possession of this land or property to the party, otherwise there will be no recovery or there will be no compensation. So, these are interlocutory order. Rule 10 also talks about the in case of money, immediately court will order okay, now you should deposit this money. If you court feel no, this will be, otherwise plaintiff will suffer or the party will suffer who is asking for relief. Other movable item capable of delivery, the court can order such item to be deposited in court till the time the dispute is resolved. As per the wish, court can say no, this property should be deposited in the court. So, these are interlocutory orders based on interlocutory applications. Interlocutory orders are nothing, you can call it interim orders, you can call it, because temporary injunction just a kind of a nomenclature, but basically you get order, interim relief on the basis of interlocutory applications, what you file during the pendency of the suit. This is what you have to understand. For saving your property If there are chances the property can be wasted, if there are chances, I mean opposite party can damage your property, immovable property can be damaged, opposite party can waste your property, opposite party can alienate, sell out your property, or this property can be sold out in execution, or there can be breach of contract. If this kind of apprehension is there, then through interlocutory applications you can get interlocutory orders. These are only examples from 6 to 10, just to make you understand what is in temporary injunction. Otherwise, if I say just okay, this is judicial remedy, which is I mean by which the party is being compelled by the court, okay, either to do this thing or to refrain to do this thing, to do a particular act, is not enough. If you do not understand okay, this can be the examples of interlocutory orders: sale, in case of sale, in case of money, in case of land, in case of search and seizure, search and inspection of property, this kind of order can be passed by, and these orders are called interlocutory orders and interlocutory applications. We have few case law also. You can go through these cases: Martin Burn Limited, Odisha State Commercial Transport Corporation, and these best sellers apart from this Manohar Lal Hira Lal case, and especially Dalpat Kumar versus Prahlad Singh case, and this one Manohar Lal versus Seth Hira Lal. One more thing we have discussed, we have section 151 in this particular case, Manohar Lal case, 150, that is inherent power of court. Inherent power is basically is not substitution for this order 39. This 39 is a specific provision. When you do not have any specific provision, then court can pass any order under section 151 of CPC also, that is under inherent power. You cannot club it together, okay, this is inherent power if order 39 is there, and if order 39 is covering some specific situation, then that order must be passed by guaranteeing injunction under order 39 of CPC instead of guaranteeing order under section 151 of CPC. Both are two different things. Inherent power, if the order 39 is not covering any situation like wasting, damaging, alienation, selling out in execution, breach of contract, if these apart from this thing, if you find anything else, then you can get relief under section 151, inherent power of the court also, because under inherent power of the court can guarantee you any relief. But if there is a specific provision, then court will say no, instead of filing a 151 application, CPC application, you should file order 39 application. Then again this would be a wastage of time. So, you should understand the basic difference between order 39 and 151, inherent power. I am writing this one, inherent power of court. This is when your order 39 is not covering any situation, only then you can file under section 151, and this has been decided in Manohar Lal versus Seth Hira Lal case. This is all about order 39 of CPC, temporary injunction and interlocutory orders. I hope if you attend this session as well as read the basic provision rules of order 39 of CPC, then you can easily come to know what is interlocutory order, nature as well as meaning, and apart from it all those 4 situation: prima facie case, balance of convenience, irreparable loss, and conduct of the plaintiff. Then you can understand it. If you study anything in isolation without going through basic provisions, then I doubt you will understand it fully. Thank you.